Greenberger with Greenberger Brewer LLP and selfstoragelegal.com. He was doing our legal update last trade show as well. So thank you, Jeff, for joining us.
Oh, thank you very much for having me back, even though it's whatever this is now, the new world. Excuse me if I look a little bit like Albert Brooks from Network News. Our air conditioning is out in the office today. They promised me to be back by now, but it isn't, so I'm not wearing my sport coat. So I'll do my best and sweat through it with you. So design today is a quick 30-minute topic for you, and then 30 minutes open for some questions. Brian has promised to tell me if I go on more than 30 minutes right now with my my topic, and then we'll have some question and answer time. So get them ready, get them sent in through the chat box in the bottom, and we'll go from there. So I just wanted to talk about maybe 5 or 6 things that you could still be thinking about doing even during this pandemic, you know, while your offices are either sort of locked down, while you're seeing 3 people through windows, or as Brian's doing, you know, 1 at a time. But if I don't think any of you are necessarily slow, but maybe things are just a little slower in the office, or maybe you're just thinking about what else you can do to legally to keep up while things are just a little bit strange. And that's what I wanted to talk about with you today. Farmers use the winter to retool, right? That's when they sharpen their blades and change the oil in their combines and whatever else farmers do. I'm not going to lie to you and tell you I know a lot about farming. One of the things that a lot of my clients have been doing is they've been taking a couple days during all this and revisiting their rental agreement. You know, some of you have been sending them to me and you haven't looked at them in 30 years. Some of you haven't looked at them in 10 years. Some of you have looked at them in a year or 2. But if your rental agreement is 5, 10 years old, even older than that, it's probably a really great time to just take a quick look at it and make sure you're up to industry standards. I think back to 2007, 2008, and I'm sure Larry will remember this as well. And if any of you out there are old enough to remember Flip Wilson, the comedian, he had this great routine about staying on too long. And then he stayed on longer because he realized the audience realized he stayed on too long, and he didn't want the audience to realize that he had realized he'd stayed on too long. I had a lot of clients in 2007, 2008 take payment agreements from people that didn't pay, but then they couldn't kick them out because now the tenants owed them 3 months rent and they'd never get it. And then it became 4 months rent, and then it became 5 months rent, then it became 6. Well, now I can't kick him out because now he owes me 6 months rent. One of the things that those clients really missed out on, in my opinion, was the real surge for inventory when everything started shaking loose. Meaning people who moved out of $3,000 and $4,000 a month rents and apartments and mortgage payments and started moving home or combining residences to move in with friends, all of a sudden didn't think $200 a month for a storage unit was terribly bad. And we were stuck with people who weren't paying us $95 a month for that same unit. It's a great time to be ready with a fresh, updated rental agreement because there is going to be some attrition. So it's a nice time to look at it. You don't have to look at it with us, but just at least eyeball it. If it seems out of date, if it seems out of style, it might be a good time to call your attorney, whoever that is, or us, and have it looked at. A good rental agreement should at least be revisited every 3 to 5 years. That doesn't mean it's going to need dramatic changes, but it should at least get a quick look, see, and make sure it's fresh and right and up to speed. Not that the Kansas statutes had a lot of changes in the last 3 to 5 years, but just law itself, developments themselves, and especially, one thing I'll point out is a lot of people who are now moving to these online rentals, you're sort of forgetting that when you move to online rentals, you need to ask things differently. You need information differently than you did 5 years ago. And you need to ask those questions differently. I mean, to ask a question about vehicle storage the way you did 5 years ago online, you're not going to get the same answer anymore. So consider retooling your rental agreement. Few thoughts. Are you still statutorily compliant? I'll just point out, in Kansas, I don't want to reread a whole statute to you, but Do you at least have that statement in bold type advising the occupant of the existence of the lien? Have you read the lien recently to make sure you're stating it correctly? It's all there. Do you have a statement in bold type advising the occupant that the property stored in the lease space may be sold to satisfy the lien if the occupant is in default? And in bold type, most people don't do this one, any proceeds from the sale of the property which remain after the satisfaction of the lien will be paid to the state treasurer if unclaimed by the occupant within 1 year of the sale of the property. Super stupid, simple, but people miss it. I mean, don't miss the easy stuff. Have you dealt with vehicles inside and out? I see a lot of people who say they got a free lease because they got it with their software, like SiteLink or Storage meant to give you a free lease. They didn't. It's a placeholder. It's old. It's out of date. And it doesn't deal with vehicles being stored in any way, right? You can say, well, you know, vehicles in a unit, it's in a unit, right? Oh, really? So you don't want any different rules about vehicles being stored in units, like you don't care who owns them. You don't care if they're insured. You don't care how much gas is stored in them. Nothing, right? Now that's important to you? Okay, I disagree. I think you should. Towing is not necessarily a given, but I still think you could address, at least for outdoor vehicles, your right to tow like a private parking lot. One of the things we see a lot of nowadays is modernizing access control. I don't mean to sound like Annette Funicello in an orange juice commercial, but access control isn't just for non-payment anymore. If any of you are old enough to recognize that joke. You know, access control is a lot more now, right? If police are there with executing a search warrant, you may not want people coming and going. If you're in the middle of an ice storm, you may not want to open the gate for people. If your gate system is down, if you're seal coating, any of those sorts of things, you may not want people to be able to come and go. You may need to have these quick trigger denial of access without upsetting everybody. Well, they may be upset, but you need a clause to control that, not just for non-payment of rent. Same with payment, especially now we want to be as contactless as possible. Many of you may want to move away from cash. You may want to move away from money orders and drop slots, all those sorts of things. You need to tell people what those rules are. People are really fast now to throw the discrimination card. We talked a lot last year at your meeting, and I will not necessarily spend a lot of time, although I have it in the next slide, about the dip the chip issue on credit cards, right? If you're not dipping your chip, you're setting yourself up for an easy fraud claim. You got to tell people what your rules are on these payments, because otherwise people are going to get to a couple days before sale and say, here, I want to pay you by check. And you're going to say, I don't want a check. And they're going to say, why not? Well, I don't take them. Well, where does it say that? Is it you don't want to take it because I'm African-American or Muslim or whatever discriminated class they think they are? And that's a big deal right now. I mean, you can't deny that that's not going on right now. Revisiting gate hours. One of the calls I've had more than ever over the last year or so is people who've started saying, you know what, Jeff, this 24-hour access thing is for the birds. Why do I need facilities that let people in at 3 in the morning, or at least everyone in at 3 in the morning? Can I get away from it? And the answer is yes. You have to start working away from it, but you can. But you have to work away from it. You know, I don't know that it's a competitive advantage to have everyone able to come in at 3 in the morning. If you have someone that really needs it, maybe you can give it to them, make them prove it, or hear me out on this, make them pay for it. One of the other things we're seeing, of course, with the economic downturn is people are, again, choosing to use their storage units as their living facilities. Brian's closed his bathrooms, which helps a little bit, but you want to probably have a definition of loitering in your rental agreement so you can help the police roust people out a little bit easier. Why does anyone, except moving in and out, need to be in their unit regularly for more than a couple hours a day? But you need to have it in your rental agreement so you can show people. And again, what services are you now providing or not providing that you used to not provide or that you're now providing because of COVID? You've always got to keep looking at those things and just make sure you're saying what you mean and meaning what you say, because if you don't, someone's going to burn you on it. And then audit your rental agreements. You know, you've got these drawers full of them or computer files full of them. Are they completely filled in? And maybe the most basic question, are they signed? When I go on site with clients and I open drawers, I can find up to 25% of rental agreements aren't signed. How does that happen? Oh, well, it was our Saturday employee 2 years ago. She wasn't getting them signed. She didn't understand how to use DocuSign or something like that. Well, great. What have we been doing for 2 years since then to get them signed? Oh, we should have been? Yeah, probably helps a little bit. They're month-to-month agreements. They renew, so we can require people to come in and sign them. Is the military question properly answered? I know last year I went over this with you all, if you were there, a lot. You know, by federal law, you have to ask if they're in the military. I see more and more people not understanding what that question means and therefore getting the answer wrong. And it's not really about the person themselves being active duty or not. It's the question about dependents being wrong, right? More and more I see my clients, especially with contactless remote signings, having 89-year-old women coming in having checked yes to the dependent question. Really, I have to ask, who are we thanking for their military service? Oh, my husband was in World War II. He's been deceased now for 35 years. Okay, so thank you for his military service, but you are no longer a dependent of his for this purpose. I don't want to go to court if you default next year and spend 90 days in court and $3,000 with an attorney to kick you out. You seem like a nice lady, but I still don't want to have to do that. So we're going to have to change that answer. And the more touchless or remote leases we're doing, the more that question is being answered wrong. There is nothing wrong, in my opinion, with even with doing remote rentals, stopping someone on the way in and saying, may I please see your ID? May I please review a couple quick things with you? One of which is, you answered this military question, yes. Can I just clarify and make sure the correct answer is yes? Can I clarify you answered yes or no to this vehicle question, right? You said no to a vehicle. Really, are you sure? No motorcycle, no snowmobile, no jet ski, really? Just want to be sure, okay? If you're going to do email, do you have appropriate consent, right? And if you're going to do appropriate consent, do you have a way of making sure that you have a way of understanding if that consent is withdrawn? Now, Kansas is not one of those states, but a lot of you cross state lines into states where you have to have a more affirmative type consent, and that's why I wanted to mention that to you. It really scares me in states where you have to have more than just provided an email address. But I still think in Kansas, you can get screwed up on that, right? You're allowed to use default by email if the occupant has provided an email address. What's it mean if the occupant one day comes in and says, stop sending me those things by email? What happens if that's your Saturday break employee? Does he or she know how to handle that statement? Just curious, because the law hasn't really developed in Kansas on that subject yet, but I would contend that that may be enough of a withdrawal of consent that you need to go to verified first-class mail or regular mail again. There's just no law on it, and it makes me a little sleepless at night. I keep, if it didn't give me cancer, I keep the Zantac still. Makes me worried. So props. You know, those things just make me wonder whether we should be using email as our only method of default notices still in Kansas. It's not as bad as other states, but I still wonder, you know, you're walking through the facility one day and some tenant screams at you like, hey, stop sending me them emails. What's that mean? I don't know. Do you have more than one space rented on the same rental agreement? I dislike that very much. I see a lot of that when I audit leases. You know, you come in and you rent space 204, you want to add another space, so manager just writes, oh, and now we're going to rent space 406, and both people initial it and we add another rent to it. That's a horrible way of doing business. And this is a really good time to clean that up. Each unit should be on a separate rental agreement. It gets really bad and confusing when people start having multiple units on one rental agreement, because how do you terminate one? when it comes time? Or how do you switch? It just becomes a mess. And oh yeah, let's say you have a value limit in your rental agreement. Let's say you limit people to a $5,000 value per storage unit, but now you've got 3 units rented on one piece of paper and there's a loss. Do I get to stack my value limits? Do I get to come to you and say, oh, hey, I had a loss, and since I've got 3 units rented on one, I'm coming to you for $15,000 worth of claim? Because I'd argue that. Keep them separate. Got to keep them separated. I'm sorry. Break into song, that's not good. All right, so please, if you go through your audits and you see that you're now renting 2 or 3 units on one piece of paper, let's take the time to break them up while we've got a little free time, a little downtime. Our units are all rented anyway. This is a good time to clean this stuff up. If someone really wants to make a stink and move out, if I understand Larry correctly, there's plenty of room to kick them out and move new people in. And then, are you still asking the question about authorized access? Because if you are, please let me know. I'd like to have that conversation with you. It's a horrible question to ask. You're implying that you're the gatekeeper, and I'd really like you to get away from that question. It leads to 3 or 4 really, really, really disastrous results later, right? Especially when there's a domestic relations dispute. You're the tenant, but you're authorized. Now, these people start fighting. Cut the lock off for me, cut the lock off for me. Don't let him in, don't let her in. It's terrible. You should have one person that you owe a duty of loyalty to per unit. I'm not saying don't have an authorized additional contact or alternate contact. That's totally different. But authorized access should go away. That should go the way of the dinosaurs. Likewise, I would really strongly encourage you to get rid of emergency contacts. The Kansas statute does not define what an emergency is. Your lease probably doesn't either. So when you contact somebody who's an emergency contact, you're opening yourself up to a claim. You contacted my mom because I was behind in my rent. Does that make me, I don't think that's an emergency. Why'd you do that? Now you're in a fight. You don't need to be in that fight. Don't do it. Just ask for an authorized additional or alternate contact, not access, not emergency. Define what it means and just be done with it. That's the person you send the additional notice to or call if you can't reach the person or they go delinquent in their rent. As promised, credit card acceptance. If there's one issue I keep hearing about every day, more and more, it's going to have to make my top 10 list pretty soon, is more and more disputes on credit cards and the nightmare it's become. We spent a lot of time last year, and I don't want to bore the people who heard me last year about the dip and chip thing. And it's still not really a solved issue in our industry. But please recognize, until you get a chip reader and can dip chips, almost any way you take a credit card is going to subject you to a dispute that you might or will lose if the tenant says the credit card was used fraudulently. So let's make sure we really understand when we start to take credit cards more and more remotely, that sets us up for more and more disputes for fraudulent credit card charges. I'm not saying don't do it, but what I'm saying is the more you can get a credit card in your office swiped, the more you can get them on video using it, and the faster you can get chip readers in your office. They're not available yet. Please do so. Just please be aware of this. And, don't let people get too far ahead of you on credit card payments. I'm really encouraging my clients, get away from the 3, 6, 9, 1 year in advance payments. Just do it month by month so you can show a pattern. Let them do it over your website so that they insert the data. So at least we have an ISP to trace back to show that they entered the data, we didn't. Anything you can do to separate yourself from entering those numbers is going to be a little bit better. Anything you can do to have them come in and swipe the card, a little bit better. But man, just so you know, within 2 years from now, the rules are changing. These are the credit card company rules. These are not my rules. These are not targeted at self-storage. This is everywhere. You're not going to be allowed to take a credit card by phone anymore at all. It's only going to be professional call centers They're going to be allowed to take a credit card by phone. So you're not going to be able to have your manager take a credit card by phone. So get set up for it. Start getting ready. Move away from it. First of all, it's bad practice anyway. You don't want your managers writing those numbers down and putting them in the computer later in the day. You don't want people with idyllic memories memorizing them anyway. But it's just, that's one of their rules. That's like 2 years ago when they changed the rules and said, any fraudulent charge not by a dip chip, we lose. This is their new one and it's coming. So yes, you'll still be able to call LL Bean and order moccasins over the phone. Yes, you'll still be able to use whichever phone center to take a credit card payment, but really it's going to move more and more towards web payment. It's going to move more and more towards professional call center, but just understand, if you think you're going to still be able to take a credit card by phone in a year or two, all that PCI compliance stuff is going to force it away from you. So get ready now. Start weaning yourself. Okay. Online rentals. We need to do more social distancing. I'm generally in favor of it, but remember, there are things that we lose, right? When we do online rentals. I think I've mentioned most of these already. You still need somehow to get a photo ID, whether they bring it to the window, press it to the window and you take a picture of it with your phone, whether you ask them to please stop by the office and still let you, slide under the door and you scan it or something. You still would really rather have a swipe or a dip of a chip of a credit card. And remember, your software can't do addendums for everybody, right? So if you're using a vehicle storage addendum or an extended hour addendum or allowing them to use electricity or water, your software can't produce those for specific uses. So you still need to have them stop in if you need them to use an addendum with you. You also lose out on two other sort of, boy meets world talks, right? You lose out on the ability to have that proper lock talk. So many of you, including I know Brian, likes to really remind people how important it is to use a disc lock, right? We're starting to get to the point where we're saying it's mandatory in the industry, and I couldn't be happier. You just don't want people using a luggage lock or a cheap little master lock that I can cut with the cuticle clippers. If I can cut it with my toenail clippers, it's not a good lock. We lose that opportunity to sit down and say to people, let us sell you a lock or let us give you a lock. What a lot of my clients are doing now is they're including it in the admin fee and it's in the unit when they go there to move in. We just pre-stock the unit with the disc lock. We just say your admin fee includes a disc lock. When you get to the unit, it will be there. We've even cut the corner off of it so it's yours and you can open the blister pack. I think that's wonderful, but think through that. I still want you to be able to go to court and say, Judge, I desperately tried to get them to use a disc lock. If you're not going to require it, I even went so far as to put one in their unit for them to use. Brand new blister pack, 3 keys, everything. And the same is true with insurance. As much stride and as far as we've come with insurance, we're now taking a step back on getting people to understand the value of contents insurance. And I have about 5 or 6 minutes left, and I only have 1 or 2 slides, so I'm good. Let me just say this to you. Do you think there's any coincidence that you can't walk in now to Public, Extra, or any of U-Haul, whoever, any of these big guys, and be told that you can't rent unless you either provide proof of insurance or buy it from them? Those guys are really smart. They have a lot of MBAs working for them. They've done the math. They know what a gigantic 50, 100 unit, burn to the ground kind of claim looks like. And they've decided that rather than getting all $8 on a rent each month, that it's more economically efficient for them to have everyone on insurance. And notice, I know Public owns their own insurance company and all that. There's excuses for some of it, but notice it's all insurance. Not many of these big guys are going protection plan. That says something to me. It says a lot of MBAs are coming to a very interesting conclusion that insurance and mandatory insurance of one form or another is the way to go. Boy, that says a lot to me. No offense to the protection plan companies, but I can't get around that. If protection plans were it, then Public would have a protection plan. They don't pay those MBAs to sit around on computers all day, chained to their desks, to not notice that. So, to the extent that you are still afraid to say to your people, look, you either bring me renters or homeowners insurance, which, by the way, just so you know, doesn't really cover your tenants very well, or we're going to enroll you in an insurance plan we've got here. And I don't endorse one over the other. You can use, Bader, Store Smart, Zercor, whatever, SBOA. Just have something and press it into their hands and tell them they got to buy it. Because when the fire comes, rather than saying to them, thanks for being a customer, you lost everything, please be out by tomorrow, and having all that bad public relations and all that bad social media, you can say, and you see the guy or lady at that table over there with the checkbook, they're going to write you a check. Right? Everyone's a little better about it. And they get out faster because they got a check, they signed a release, they're gone, they're out. You can start tearing down and rebuilding. It's just so advantageous. I don't get it. I don't know why we're still afraid of it. And you can do it in Kansas. It's a doable thing. So please stop being afraid of it. All right, one more thing before I go to questions. If I'd like to remind you again, if you are still unsure about your lien process, if you feel like your managers are not doing it right, if you feel like they're scared of it, if you feel like you need more guidance, if you do not like waiting in line at the Jeremy post office, we still offer late to lien, and it's our service that does the automated late and lien noticing for you. I'm going to go through these 2 slides very quickly for you. If you are interested, you can contact me. You can contact the number here, the 513-204-9633. It's an automated service. I don't think I mentioned last year, there is no setup fee. There's no monthly minimum. There is no onboarding fee. It's just a $12 per use fee when someone goes into default. You set the number of days in default when we start between 2 and 29. So it's a really effective and efficient way for us to take over your lien noticing if you don't know what you're doing. We have clients from a 100-unit facility up to some of the largest non-REIT private companies with 200 and 300 facilities. They all use us. They all fit in the same system. It works really, really well. We'd love to have an opportunity to talk to you about it and see if it's something that would work for you. Like I said, it doesn't cost much. We put it into your lease that the tenant reimburses you the $12. So it's pretty revenue neutral for you. We save your time, your staff's time, and we improve payment time by about 35% according to our customers. There's 2 slides here. I just had to show you new origami. Last thing, if you do want us to review your lease, I'll put up a slide in a couple of minutes with some information. We do lease reviews at no charge whatsoever. We'll call you after we're done, be a little patient with us, get back to you, tell you what you think. You don't have to use us, even if we review your lease, just to tell you what we thought. So you can't beat the price of free for a lease review right now. It's a good time to do it while you're retooling. All right, let me, if it's okay, Brian, I'll put up the Q&A slide. I think I saw that there's some questions in the queue.
Yeah, we have one question.
I've got the PowerPoint up. I can't see the queue.
Copies of your slides.
Yeah, Brian, I'll send it to you, and if you want to distribute it, you can.
Okay. And then I had a question about what your thoughts were on the Family Medical Leave Act, or the coronavirus, the Family's First Coronavirus Response Act.
Yeah, this is a bit of a morass for everybody. Let me start by saying it was very hastily written legislation, and all legislation is probably poorly written to begin with, and this was really poorly written. What I understand of it is that a lot along the lines of what Brian said, but my understanding a little different than what Brian said is, while you do have to give a FEMLA type time off with paid time off, where you didn't have to if you weren't otherwise offering paid time off because you didn't meet the FEMLA 500 employee requirement or 100 employee requirement. There is a cap on it. I think it's 80% of the paid of the employee's pay. And my understanding is, not that it does you a whole lot of good right now, but you do get to take a state tax credit against that payment. So while it stinks, and I'm not sure, I mean, it really hurts a self-storage business that may only have one or two employees. It's not like, a school district that says, okay, Mrs. Smith needs to take off the next 6 weeks and we'll substitute teacher her in. We have to do it. And you really do need HR help. I'm not a commercial for any particular business, but I will tell you, in my law firm, we gave up a couple years ago and we hired something called a PEO, which is a professional employee or employment organization. So essentially, I don't work for myself anymore. I hired myself through a company that does all of it for me. We pay them a fee and they do our payroll, they do our health insurance, they do our 401k, they do our cafeteria plan, and we can offer benefits and other things like we have 600,000 employees that we could never offer. And therefore we have an HR department like we couldn't have if we were just our 15, 10, whatever people that we are here. And I've been recommending to my self-storage clients for the last about a year, and now I'm really amping it up. It's probably time to just move under the safe umbrella of a PEO and let them handle your human resources for you, and let them tell you when you have to give off, and let them manage the payroll, let them manage your workers' comp, let them put you in bigger, safer groups of workers' comp, because this stuff has just become insane to manage. We're lawyers and we can't manage it ourselves, and nor do we want to. We bill by the hour. If we spend as much time as we needed to on these type of things, we wouldn't be able to stay open. But I can tell you, Brian's just about right on it. You've got to give them a certain number of hours off. I think Brian was right. I think it's up to 20 weeks. It's 80% of their pay. I was told by our HR folks that we could ask them first to use up any unused paid leave time before we put them in that, but that they wouldn't like it. Well, I don't care. But you should check with your own HR people first before you decide that. What we did is we made them use their own paid time off between the time they announced it and the time that they got their test, because some of them dragged their feet to get tested. Once they got their test and until they got their results, we gave them full paid time off. If they were positive, then we put them on or if they told us they needed off for family, then we put them on the 80% stuff. That's how we're handling it. I'm not sure we're right. I will tell you the legislation is, I sat and read it a couple times, and you just scratch your head and go, who with a crayon sat down and wrote this?
I have a question here. Are we liable for mold in units?
Well, yes and no. I mean, first of all, you should have a clause in your rental agreement that says you're not. The way that you get mold in units is because there's not just water, but there's got to be a consistent source of moisture. So I would say you are generally held liable for mold in units if there is regular moisture in units, you know about that regular moisture, and you fail to do something about it. So I have a client that has a leaky roof, and he kept putting chewing gum on it, and he didn't fix it. And yes, you're going to be liable for that kind of mold. But if you've just got someone who brings wet furniture in, puts it in the dark, it's cold, and things get moldy, we generally say we're not liable for that. We'll fight that one, right? So it depends. It's got to have a regular and consistent source of moisture. If something just comes in wet and no other water is introduced, the walls don't sweat, your HVAC system is balanced, you've got enough dehumidification to handle it, you're not going to have mold. So one of two things is happening. You've either got a leak, your humidity is not balanced, or the tenant is introducing water. If the tenant's introducing water, I'm not liable. If I'm doing something wrong and I'm not correcting it and I know about it, that's generally considered negligence, and therefore I'm liable.
But the safest thing to do is have it in the rental agreement.
Obviously have it in the rental agreement. And the other thing is, once you hear you've got a tenant that's got mold, you should be inspecting units around it. I don't like cutting locks off any more than anyone else does. But once I hear about mouse droppings, once I hear about mold, I'm going to go look in other units. If I can look over the top, great. If I can't, I'm going to ask to get in. If I don't get let in, I'm going to go in. I hate to do it. One of my little Jeffisms, you know, the sayings I say at every trade show that people like to quote me on is the greatest invention ever in self-storage is a GoPro. Own them. When you go into a unit, wear it and film everything you do, from lot grind to replacement and numerical seal.
I have another question here from earlier in this month. Someone asked about the proper lien sales procedure during coronavirus. Has it changed at all? Is there an ethical component to it? What is the lien sales procedure in Kansas? How's that changed?
Well, I don't, I mean, you have in Kansas a state of emergency. I know of nothing about the state of emergency that has actually stopped your ability to conduct a true lien sale. Now, you may want to check with your own local council on that, but I don't know of anything. Now, let me qualify that by saying there were things that stopped evictions. To me, a lien sale is not an eviction. An eviction is where you serve a notice, you serve a summons, you go to court, you ask the court to grant you restitution of a unit. The one thing I think that you couldn't do, and I still am under the general impression you can't do in Kansas, is you can't have a public gathering of more than a certain number of people. I don't know what that number is right now. I think it varies by city or county right now. It's somewhere between 10 and 50. Is that right, Brian? 7, 6. So you can't have live auctions. You're going to have to do your auctions online.
Yeah, I think it's under 15, the last I heard.
Oh, okay. So I don't recommend live auctions, but I don't know of any reason that you can't do an actual lien sale right now. Now, I say that, and I've been answering this question 20 times a day since about March 30th. And here are my precautions. I can't keep track of every fiefdom in every state, right? There are counties, there are cities, there are town councils who have lots of do-gooders who try to stop things. I'm answering from a statewide perspective. If you've got a city council that doesn't want something done and they've passed an individual town ordinance against it, I'm not going to know about it. You would have to know about that. Number 2, this thing goes in and out of control all the time. Right now, as it sits, I don't know of anything that stops a lien sale in the state of Kansas. That doesn't mean that 2 weeks from now, the governor might issue a different order. That, you know, that changes rather constantly. So that also makes it difficult for us to know exactly what to do. But as far as we know now, you can do them. What we are telling our clients is get while the getting's good, because it may not last. And, you know, I think as weather gets colder and people move indoors and, you know, the virus might get worse again. Not that it can't, you know, it seems we're getting worse now, but I mean, worser, if there's such a word. We worry about that. Obviously, we encourage you to talk to your own legal counsel and make sure your own legal counsel is on board with you doing lien sales. But from my vantage point here, looking at this, representing, you know, national clients who have facilities in Kansas, we are allowing them currently to proceed with lien sales in Kansas.
Okay, and then what's the best way to handle tenants that die? And how does that relate to access to family members, especially in the case where no family members are listed as an emergency contact or a second?
Well, that is the number one question we always get, always have, and I think we always will, regardless of COVID, right? And it's a multi-pronged, fact-specific answer, Brian. You know, what you want to do first is obviously ascertain. You need to ascertain and make sure that you're being told the truth, that the tenant has in fact passed away. If the tenant has in fact passed away, the next thing you want to know is, has any family member gone to probate court and become the official representative of the estate, right? A representative is generally known as the executor or executrix if they're female, or administrator or administratrix. If someone has done that, and there's all sorts of ways that can happen in Kansas, formal court proceedings down to some form of an affidavit, then we need proof of that paperwork. We need proof that no one else has filed contrary to that. And then if they are the representative of the state, then we would deal with them. If they haven't, then we need to encourage someone to become that appropriate representative of the estate, right? If no one will do that, then your safe option is to become, to probate on behalf of the family, right? As a creditor of the estate. That's an expensive and generally unfortunate last worst option. Sometimes there's other options, like people have keys to the unit and you can quietly negotiate letting them in, because you really can't stop someone with a key. And that works out well sometimes, but obviously you'd rather know that the person who actually has become appointed by the probate court to gather up the assets and marshal the assets and the debts of the estate is the person that you're dealing with. So it's one of those things that the answer is never the same twice. Before COVID, we called my 26 stop speaking tour in 2019, the Dead Tenants Tour. That has now been considered in bad taste. So we retracted the t-shirt that we made, but it is the number one question and it's very fact specific. So obviously step one is to make sure it's true. Step two is to ask or request that the family member who's asking you go down to probate court and become the representative, either because the will appoints them or if they're not. I mean, the only difference, Brian, between being an executor and administrator is the executor is named in the will, the administrator is appointed by a court. Other than that, the powers and the responsibilities are the same. And becoming the executor or the administrator doesn't mean you get everything. It just means you're the named representative. You're the person responsible for marshaling the assets and the debts. It doesn't mean you get dad's ship in a bottle collection.
Another question here. So as operators, we should not be the gatekeeper of our facility. So if they have a gate code and key to the lock, they are allowed to get in technically, correct?
We try not to be the gatekeeper because, again, that implies that we would stop somebody for not, for not being listed on the rental agreement, or that someone could call us and tell us to block somebody, even if they have a key or a code. I between friends on this call, I think gate codes are window dressings, right? Some of you offer units as low as $35 or $40 a month. If I rent a unit from you for $40, don't I have a gate code for 30 days? So unless you have door alarms, I can come and go from your facility for 30 days for $40. If I have a key, I can also go and come from that other unit. So I don't tend to worry too much about gate codes, and that's why I don't want to know too much, right? I tend to like to remain Switzerland in this thing. I've given you a code, I've given you a lock or sold you a lock or told you to put a lock on the unit. And after that, how you manage your business with access to that unit is yours. And please don't put me in the middle. I get calls every day from people who are getting divorced. They don't want their girlfriend or ex-wife or whatever in the unit. And I'm like, don't get involved. Tell them to change their lock, or tell them to change their gate code, or get online and make those changes. We do not want to be dragged in the middle. We hear a lot of stories as managers about people getting beaten or abused or domestic violence or whatever, and we never know the truth. And it might be true or it might not be true, but why do we want to be in the middle of that, right? Because it may not be the truth, or it may be half truth. And we make these assumptions, oh, well, we should let her in because she's the abused spouse or he's the abused boyfriend. It may not be true, and we've made these assumptions, and that's always, that all that does is buy us a lawsuit that we don't need to be in the middle of, right? When we do this business properly, it's a very simple and brilliant business plan, right? We rent you space, you pay us rent, and we stay out of your business.
I got one big question for you. I think this may be the last question. Unless anyone else has any questions, it's a good time to submit it on the Q&A box or the chat. This question is has a lot of other questions built into it, but I had this question specifically from one of the members. They were actually one of the attendees earlier, but I think they got off the call. Bankruptcy. If a customer goes bankrupt, does the bank own the property in the unit? And are they liable for the bank rent? And then with that, what are bankruptcy notifications like in the bankrupt tenant procedure in this kind of situation? And then what's the best way to protect yourself from bankrupt tenants?
That is a loaded question.
Yeah.
So let me start by saying that the simplest way to protect yourself from bankruptcy is the hardest pill to swallow, which is the one I've been banging on the podium for 25 years, which is when you rent to someone, get their social security number, right? Having a social security number gives you, among other powers, the ability before you do a lien sale to check a federal database called PACER, P-A-C-E-R. That's an acronym. I do not know what it stands for. It's the federal government's docketing system for their court system. And it will tell you whether someone's filed bankruptcy. And the smartest thing you can do before the day of a sale, the day before a sale, a week before a sale, maybe all 3 times, is run the debtor's name and social security number through PACER and make sure they haven't filed bankruptcy on you as a surprise. Now, you might say to yourself, Jeff, wouldn't it be incumbent upon the debtor to tell me they filed bankruptcy? And the answer is yes, that's actually the law. They're supposed to tell you. You might be surprised to hear that debtors lie, right? So the debtor will say, I did tell the operator. I yelled it across the street at him. I saw him at the grocery store and told him. I faxed it to him. I can't help it he didn't get it. I emailed him. It may have gone to his spam folder. That's not my fault. I did what I was supposed to do. I filed 2.5 minutes before the lien sale. He may have been outside selling my stuff. He may have not been paying attention, but I got it to him first. He sold my stuff. He violated or she violated the automatic stay. And now I want him thrown in jail. And that's what happens. And judges in bankruptcy are not full federal judges. They're Article 9 judges instead of constitutional Article 3 judges. So they don't get lifetime appointments. They have big chips on their shoulders. They have no senses of humor. And they do tend to be very upset when their orders are violated. And it's just a matter of facts. And why get into that factual dispute, right? I could very quickly flip if I really don't want to do all your recording, but I could show you what a lot of my clients do now live is they have a little numbers only keypad. And do you guys mind if I just jump out of this slideshow for 1 second? Is it okay? I'll just show you a quick picture from another slideshow I did recently. Just make that large for you. Do you see that little digital keypad at Citadel Self-Storage? I don't know if I can make it any larger for you. All it has is numbers and an enter. That is a screen forward facing to the customer. When it's time for the social security number, the manager just looks at them and says, type your social security number in. They get no grief. The manager there says they never get any problems. With online rentals, it's even less problems, right? Because you just get the red X of death, right? If you don't give it to us. And then you have it. And then you just need to train your managers to run the social security number through PACER before you sell. Just like you should run your people through the military database before you sell, just to make sure they're not active duty or dependent. It's just those last minute checklist things like a pilot before taking off or landing has, you know, I don't know how many things they have. I'm guessing it's 1,000 things they need to do before they take off to make sure everything's right, because you don't get a second chance to take off the plane, right? We don't have 1,000 things, but these are things we should be doing, because bankruptcy law is like Alice in Wonderland. You got to suspend your belief in reality. It's so debtor friendly. It's written in such a way to be so debtor friendly that anything we do is going to be wrong. So we have to know, so we have to be better than the law. We have to be bigger than the law. And the only way to do that is to run PACER. And so I can tell you in this office, before we file a collection lawsuit, our paralegals run that debtor through PACER. And then before we garnish that debtor, we run that debtor through PACER, just to make sure that the debtor didn't file. And let me tell you the bigger problem with self-storage. The bigger problem with self-storage is debtors don't always tell their attorneys about the debt to self-storage for two reasons. Sometimes they don't owe us money at the time they file. Other times they owe us money, but they don't tell their attorney about the unit because they think that if they don't tell their attorney about the unit, that the trustee won't come and take the valuable stuff out of the unit, right? That's where they're hiding the Camaro. That's where they're hiding the Renoir. So they don't tell them. Then they don't realize what's going to happen is we're still going to sell the unit because we weren't named in the bankruptcy. And then they turn on us and say, oh, you sold it. Well, guess what? Bankruptcy law is so unfriendly to creditors, we're still in trouble, even though we weren't named and we weren't notified, because they were in the middle of a bankruptcy, right? So it's just so, the law is so stilted against us. So the simple way to do it, and the judges look at me all the time and say, Mr. Greenberger, you know, they have a remedy. Why didn't they just run it through PACER and they would have known for sure? Like, Your Honor, it's not that easy. Oh, yes, it is, Mr. Greenberger. I don't know what you're talking about. So now I just tell everyone, look, you should run it through PACER. That's how you protect yourself. Then, in answer to the other questions, Brian, because I know we're running short on time, you know, everything else is very fact specific. It depends on what chapter they file. It depends on how we're notified. It depends on whether a bank is involved or not. If it's a chapter 7, the trustee owns the property. If it's chapter 13, the debtor still owns their property. So in a chapter 7, you can't negotiate with the debtor to move out because the debtor doesn't really own their property until the trustee releases it, if the trustee releases it. In a chapter 13, you can negotiate with the debtor's attorney or the debtor to still come and move their stuff out, right? Whether the bank is involved or not depends on whether the bank has a lien on the property. So again, it's very, very fact specific. The number one thing I tell people when I do, other than check PACER, when I do a bankruptcy self-storage seminar, is this is the one time you can't be wrong getting an attorney involved. This is penny wise, pound foolish. It's too easy to make a mistake and not worth it to keep your attorney out of it. Now, you do not need a self-storage attorney in these type of cases. You just need an attorney who knows how to do bankruptcy creditors' rights. I will always make the offer, if you hire a bankruptcy creditors' right attorney and they have a self-storage specific question, have them call me. It rarely happens, but if they do, I'll happily try to help them understand the self-storage aspect of it. So you don't need, you know, Scott Zucker, Jeff Greenberger, Carlos Caslow, any of those people for a bankruptcy situation. You can just use a local bankruptcy attorney.
So the bank does own the unit?
Not necessarily. First of all, it has to be liened property for the bank to even be involved. The trustee is the bankruptcy trustee, and they own those. They don't own the unit; they own the contents, all the property. In a 7, in a 13 or 11, it remains with the debtor in possession.
All
Then the
right.
question becomes: does the debtor affirm or discharge or waive the lease, and whether the trustee affirms or asserts any right to the interest in the property or not. It's a very, very fact-specific inquiry. It's really complicated.
Okay. Well, thank you very much, Jeff. Thank you to all the attendees. And I think this seemed to be a very good, successful webinar. So thank you for attending. We will send out copies of Jeff's presentation, and we'll have this webinar recorded, and I'll upload that on the website as well. And I think that's it. Thanks a lot again.
Yeah, if anyone wants to send a lease to me for review, you can use that info@selfstoragelegal.com. It's on the screen right here. Thanks for having me. Hopefully next year live.
Thanks, Jeff.
Thanks,
Bye,
Jeff.
everybody. Well, stay healthy.